1973, the Supreme Court decided that a right to privacy under the Due Process Clause of the 14th Amendment to the United States Constitution extends to a woman's right to have an abortion. But that right must be balanced against the state's two legitimate interests for regulating abortions. One, protecting prenatal life, and two, protecting the mother's health. Roe v. Wade essentially removed all protection for the unborn. It has resulted in untold lost energy from constant divisive bickering and political maneuvering. The loss of population has arguably led to much of the economic unraveling of the country. How a decreasing number of people working is supposed to support an increasing number of people retiring is a problem that a lot of the geniuses obviously haven't thought through. I believe we fail to act decisively on this issue because we are not really in touch with the stark reality. There is a stark reality involved here, and if you don't believe religion and you don't believe basic traditional morality, you better believe mathematics and science. Let me read to you from something Congressman Ron Paul said in his book, The Revolution. One of the most contentious issues in our public life over the past 3.5 decades has been abortion. As a physician, and in particular as an obstetrician who has delivered over 4,000 babies, I have always had a special interest in the subject of abortion. When I studied medicine at Duke Medical School from 1957 to 1961, the subject was never raised. By the time of my medical residency at the University of Pittsburgh in the mid-1960s, though, wholesale defiance of the laws against abortion was taking place in various parts of the country, including my own. Residents were encouraged to visit various operating rooms in order to observe the procedures that were being done. One day I walked into an operating room without knowing what I was walking into, and the doctors were in the middle of performing a C-section. Actually, it was an abortion by hysterectomy. The woman was probably 6 months along in her pregnancy, and the child she was carrying weighed over 2 pounds. At that time, doctors were not especially sophisticated, for lack of a better term, when it came to killing the baby prior to delivery. So they went ahead with delivery and put the baby in a bucket in the corner of the room. The baby tried to breathe. The baby tried to cry. And everyone in the room tried to pretend that the baby wasn't there. I was deeply shaken by this experience, and it hit me at that moment just how important the life issue was. Congressman Paul was deeply shaken. Are you deeply shaken? There has been a veritable holocaust of abortion in this country and around the world. The reason that Roe v. Wade should be struck down is more a matter of common sense and traditional morality, but also law. Edward Lazarus was a law clerk for Roe's author, Justice Harry Blackmun. Mr. Lazarus wrote, quote, "As a matter of constitutional interpretation and judicial method, Roe borders on the indefensible. I say this as someone utterly committed to the right to choose, as someone who believes such a right has grounding elsewhere in the Constitution instead of where Roe placed it, and as someone who loved Roe's author like a grandfather. What exactly is the problem with Roe? The problem, I believe, is that it has little connection to the constitutional right it purportedly interpreted. A constitutional right to privacy broad enough to include abortion has no meaningful foundation in constitutional text, history, or precedent. The proof of Roe's failings comes not from the writings of those unsympathetic to so-called women's rights, but from the decision itself and the friends who have tried to sustain it. Justice Blackmun's opinion provides essentially no reasoning in support of its holding, and in the time since Roe's announcement, no one has produced a convincing defense of Roe on its own terms. End of quote. A number of scholars and even Supreme Court justices have harshly criticized Roe v. Wade based upon its legal merits or lack thereof. The Supreme Court justices who have spoken out against Roe v. Wade are White, Rehnquist, Scalia, Thomas, Kennedy, and O'Connor. Likewise, a large number of legal scholars have criticized the decision as being something far less than constitutional. Susan E. Wills is both a woman and a lawyer, and she has worked for the Secretariat for Pro-Life Activities in the United States Conference of Catholic Bishops. In an article copyrighted by the USCCB entitled 10 Reasons to Reject Roe, Ms. Wills summarizes the 10 legal reasons that Roe v. Wade should be struck down. Number 1, the court's decision in Roe v. Wade exceeded its constitutional authorities. The Congress makes laws, and they take precedence over the personal policy preferences of Supreme Court justices. Roe v. Wade exceeded the court's authority. Number 2, the court misrepresents the history of abortion practice and attitudes towards abortion. Abortion practice and the attitudes of society against abortion are very clear. Abortion wasn't a generally accepted practice in any civilized society. Number 3, the majority opinion in Roe wrongly categorizes the common law of England regarding the status of abortions. It's just an outright deception, the way they categorize the common law of England. And 4, the court distorts the purpose and legal weight of state criminal abortion statutes. Number 5, a privacy right to decide to have an abortion has no foundation in the text or history of the Constitution. In philosophy, we could say that this is something akin to a gratuitous positing, where you pull something out of thin air. The court engaged in an incredible foray in distortion and misrepresentation in this case. Number 6, the court reads the 14th Amendment extremely expansively to include a right of privacy to decide whether to abort a child. The court in Roe adopts a very narrow construction of the meaning of persons, however, to exclude unborn children. Number 7, the Roe court assumed the role of a legislature in establishing the trimester framework. And this is a very dangerous precedent where courts begin to legislate. And we have seen this problem manifest itself time and time again. It subverts the very basis of this country, the way this country was put together, the separation of powers. Courts don't legislate. 8, what Roe gives, Doe takes away. That's another case. For any reason, an abortion has to be provided up to the very end of the 3rd trimester. That's Doe. Roe didn't say that. Another case after it said that. Any reason, for any reason, an abortion has to be provided up to the very end of the 3rd trimester. I said before, and I'll say it again. If you use development, the development of the child, as the criteria for determining the humanity of that being, you're playing God. The development of the child is not the basis for killing the child. Whether you kill a child at 3 months, 6 months, 9 months, or 3 years of age, you're killing a child. You kill the child in the womb. Is it easier? Is it more defensible? Well, I guess it's easier because we don't have to look at it. We don't have to see that child smile, and we don't have to see that child cry, and we don't have to see that little heart beat. And I guess it's easier to kill what you don't have to look at. 9. The court describes the right of abortion as fundamental. A fundamental right. The right to kill another human being. The logic, the distorted logic, the tortured logic, the dark logic of abortion has to make any true thinking person shudder. The right to kill another human being as fundamental. This court will go down in history in infamy. And number 10, finally, Ms. Will says, despite the rigid specificity of the trimester framework, the opinion gives little guidance to states concerning the permissible scope of abortion regulation. My friends, the Supreme Court of the United States of America erred egregiously in Roe versus Wade, just as it did in the Dred Scott case of 1857. Because it's the highest court in the land doesn't mean it's immune from error. The reasoning in Dred Scott and Roe versus Wade is nearly identical. It's frighteningly identical. In both cases, the Supreme Court, the highest court in the land, stripped all rights from a class of human beings and reduced them to nothing more than the property of others, chattel. Compare the arguments which the Supreme Court used to justify slavery and abortion. Number 1, the words citizens or persons used in the Constitution were never intended to include blacks or unborn children. In the Dred Scott case of 1857, the Supreme Court said, "A Negro whose ancestors were imported into this country and sold as slaves were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States." Then in Roe versus Wade in 1973, the Supreme Court said, "The word person as used in the 14th Amendment does not include the unborn. The unborn have never been recognized in the law as persons in the whole sense." Hence the comparison between the unborn and black people who were slaves. And second, the right to privacy protects the decision to own slaves or to abort unborn children. In the Dred Scott case of 1857, the Supreme Court said, "A slave is the property of the master, and the Constitution has provided for the protection of private property against the encroachments of the government." Then in 1973, the highest court in the land in Roe versus Wade said, "This right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy." Third, slavery, abortion, is justified because historically the rights of blacks, unborn children, have been abused. In the Dred Scott case of 1857, the Supreme Court said, "That unfortunate race had for more than a century before been regarded as beings of an inferior order, and they had no rights which the white man was bound to respect. Then, in Roe v. Wade in 1973, the Supreme Court said, abortion was practiced in Greek times as well as in the Roman era. Greek and Roman law afforded little protection to the unborn. Then fourth, slavery, abortion, is for the victim's own good. In the Dred Scott case of 1857, the Supreme Court said, the Negro might justly and lawfully be reduced to slavery for his benefit. And in the Roe v. Wade case of 1973, the Supreme Court said, there is also the distress for all concerned associated with the unwanted child, and there is the problem of bringing a child into a family unable psychologically and otherwise to care for it. End of quote. And so they said that the Negro would benefit from slavery and the unborn child would benefit from his own murder. The Supreme Court justices are human beings. They can make mistakes, and in this case, it's an unimaginable mistake that has resulted in the death of tens of millions of the most innocent, the most helpless human beings. The fact that we've allowed it to go on, I say that very, very pointedly, we allowed it. This is not a communist country. This is a democratic republic, a free country. We have allowed it to go on. We're not serious enough about it. If we ever interiorize the reality of what takes place here, a living human being, a real human being, the entire genetic package present from the moment of conception on, if we ever really came in contact with this and realized what we had done, we would scarcely be able to live with ourselves. These are real human beings, and you don't have to believe me, and you don't have to believe religion, and you don't have to believe morality. Believe science, for with each passing day, the evidence provided by science tells us incontrovertibly, irrefutably, that from the moment of conception, you have a human life. So we have a comparison now with the Dred Scott case of 1857. Dred Scott, 1857, Roe v. Wade, 1973. Some of the comparisons are striking. Roe v. Wade left in its wake an incalculable amount of death and destruction, more than any war we've ever fought, more than any natural disaster. Well, two of the foundation stones for the court's decision are totally lacking in structural integrity, so to speak. First, the state is not, in fact, protecting the well-being of the unborn child. The state is a material accomplice in killing the unborn child. How do you protect the well-being of an unborn child? By killing it. What kind of tortured logic allows for such a position? And second, the state is fatally in error in assuming that abortion is safe. I don't know how you're protecting the well-being of an unborn child by killing him or her. And the psychological complications that have taken place or that women suffer, the matter of record. The physiological side effects include all kinds of infection and bleeding and even sterility. The psychological devastation caused by abortion is manifest in the lives of millions of women. And if we truly love women and aren't just talking about it and aren't trying to use that as some kind of a political trump card, if we truly love women and advocate for them, then we have to be cognizant of the psychological damage that is visited upon them by facilitating abortion on demand. It is a short-term solution to a very long-term challenge. So it may indeed result in a few hours or days or months of relief, a sigh of relief. I dodged the bullet. But then the poor woman has to live with that decision for the rest of her life. And she can never escape her innermost thoughts. What would this child have been like? Would this child have looked like me? And what about the millions of men? Millions of men who have been left without the blessing of a child. How many of them suffer? It's their child too. It's their child too that was killed before it ever had a chance. The babe in the womb is not a potential human being. The baby in the womb is a human being with unbounded potential. And that human being has a father as well as a mother. And how many of the men would have been enhanced in their lives had they been able to receive and raise the blessing of these children? But they too have to agonize in 1,000 long, cold nights. What would my child have been like? Would he have looked like me? Would she have talked like me, thought like me? I could have passed on so much to them, so much of my knowledge, life experience. And so the men, as well as the women, agonize countless cold nights, thinking, regretting, suffering. Roe versus Wade was not a decision based upon law, nor upon right reason, nor upon common sense. It was the epitome of government caving into its basest instincts, and under the specious pretext of advocating for women, it harmed women, and it harmed men, and it harmed society at large. It is the consummate rationalization. It's based solely on emotion and a usurping of power that neither the court nor humanity in general legitimately possess. It's the consummate example of taking a position, however illogical, however irrational, however immoral. You take that position and then you back into a defense. Society had begun to deteriorate. Society had begun to unravel morally. Society became more and more egocentric. The me generation screamed out, I gotta be me. I gotta be free. Free to do whatever I want to do. Free to have an unbridled life of promiscuity, if I so please, and if anything gets in the way of this new lifestyle, then it has to go, even if it's an innocent human being. Yes, the court sanctioned society's degenerating moral position. The court's decision is not based on law. The court's decision is not based on right reason, and the court's decision is not based on logic. The court's decision is the consummate rationalization confirming a degenerate society. And in its wake, death held sway. And now we have a country that is unraveling in more ways than one. Is it any wonder that we're having difficulty paying our bills as a country, that we can't seem to make a good decision We don't have enough people in our military. We don't have enough people to pay for the people that went before us. How can a decreasing number of working people pay for an increasing number of retiring people? We wonder why Social Security is falling apart. Demographers warned for decades about the consequences of the abortion generation. Law has been impoverished because of Roe versus Wade. Law has been diminished because of Roe versus Wade. Law has been distorted because of Roe versus Wade. We know more now than we did centuries ago, and with that knowledge comes responsibility. We know more today than we did a few weeks ago. Science has informed us in no uncertain terms that life begins at conception. And much of what we didn't know in 1973, when Roe versus Wade was handed down by the Supreme Court, much of what we didn't know then, we know now. And with it comes increasing responsibility. Life begins at conception. A human being exists from the moment of conception, and no amount of wishful thinking can circumvent this rock wall of testimony. And the testimony comes from common sense. The testimony comes from right reason, from logic, and the testimony comes from modern science. This nation and the world has been struck a blow that it may well not recover from. Playing God is not the answer to short-term or even long-term problems. In the end, even an avowed atheist will have to answer to her trying to play God by deciding when life begins and when life ends. This nation has been incredibly impoverished because of Roe versus Wade. What were they thinking? What were they thinking? In the court of history, that Supreme Court will have to plead temporary insanity, for it is absolutely unthinkable, unimaginable, based upon a right to privacy. One human being has the right to kill another human being. You don't believe it's a human being? Then you might as well go back to flat worldism. Science asserts in no uncertain terms it is a human being. From the moment of conception, you can deny contemporary or traditional morality, you can deny God, but you'll also have to deny science. And you purport to be so sophisticated and educated, yet you deny the certain conclusions of modern science. Life begins at conception, hence killing that human life is something that this nation and every member of it will have to think long and hard about it. We'll have to answer for this. How much longer will we let it go on? And as the United States and most of the Western world begins to deteriorate and unravel economically and socially, we're going to soon have to come face to face with the part that abortion on demand played in this. Quite simply, it is a position and a policy that has its own demise woven within itself. We will have to change it or face our own extinction. The economic, social, political, psychological, and other elements of our existence have been imperiled by this fatally flawed Supreme Court decision. It can be overturned. It can be overturned, and it must be overturned. Dred Scott was overturned. Abraham Lincoln saw the folly of that. The Supreme Court said, oh, they're not really human beings, so they don't really have the rights of citizens. They're not fully human. What an outrage. A civil war was fought because a class of human beings were so persecuted. They were considered property. What a disgrace. What a blight on our national history. And Roe versus Wade is every bit as much and more of a blight. An entire class of human beings, the unborn, have been discriminated against, their very existence imperiled. We as a nation and a world have to begin to be more humane, less self-centered, and more God-centered, other person-centered, for reasons at once moral, spiritual, logical, and mathematical. We shall cease to be unless we permit our unborn children to be. The dark logic of abortion has permitted outrages beyond our worst nightmares. Listen to the testimony of Jill L. Stanek, a registered nurse who testified at a hearing on the Born Alive Infant Protection Act of 2000. Quote, I am a registered nurse who has worked in the labor and delivery department of Christ Hospital. No, Christ Hospital in Oak Lawn, Illinois, for the past 5 years. The method of abortion that Christ Hospital uses is called induced labor abortion, also now known as live birth abortion. This type of abortion can be performed different ways, but the goal always is to cause a pregnant woman's cervix to open so that she will deliver a premature baby who dies during the birth process or soon afterward. The way that the induced abortion is most often executed at my hospital is by the physician inserting a medication called Cytotec into the birth canal close to the cervix. Cytotec irritates the cervix and stimulates it to open. When this occurs, the small preterm baby drops out of the uterus, oftentimes alive. It is not uncommon for one of these live aborted babies to linger for an hour or two, or even longer. One of them once lived for almost 8 hours. In the event that a baby is aborted alive, he or she receives no medical assessments or care, but is only given what my hospital calls comfort care. Comfort care is defined as keeping the baby warm in a blanket until he or she dies, although even this minimal compassion is not always provided. It is not required that these babies be held during their short lives. One night, a nursing co-worker was taking an aborted Down syndrome baby who was born alive to our soiled utility room because his parents did not want to hold him, and she did not have time to hold him. I could not bear the thought of this suffering child dying alone in a soiled utility room. So I cradled and rocked him for the 45 minutes that he lived. He was 21 to 22 weeks old, and he weighed about a half a pound and was 10 inches long. He was too weak to move very much, expending any energy he had trying to breathe. Toward the end, he was so quiet that I couldn't tell if he was still alive unless I held him up to the light to see if his heart was still beating through his chest wall. After he was pronounced dead, we folded his little arms across his chest, wrapped him in a tiny shroud, and carried him to the hospital morgue, where all of our dead patients are taken. And that's the quote, the testimony of a registered nurse. I admit that at times I have a hard time saying God bless America since 1973, when Roe v. Wade removed all legal protection for the most innocent and the most helpless of our brothers and sisters. May God have mercy on America and grant us the light to see what we've done and the courage to change it once and for all.